Rule 91. Escheats. Section 1. When and by whom petition filed. When a person dies intestate, seized of real property in the Philippines, leaving no heir or person by law entitled to the same, the Solicitor General or his representative in behalf of the Republic of the Philippines, may file a petition in the Court of First Instance of the province where the deceased last resided or in which he had estate, if he resided out of the Philippines, setting forth the facts, and praying that the estate of the deceased be declared escheat. Section 2. Order for hearing. If the petition is sufficient in form and substance, the court, by an order reciting the purpose of the petition, shall fix a date and place for the hearing thereof, which date shall be not more than 6 months after the entry of the order, and shall direct that a copy of the order be published before the hearing at least once a week for 6 successive weeks in some newspaper of general circulation published in the province, as the court shall be deemed best. Section 3. Hearing and Judgment. Upon satisfactory proof in open court on the date fixed in the order that such order has been published as directed and that the person died intestate, seized of real or personal property in the Philippines, leaving no heir or person entitled to the same, and no sufficient cause being shown to the contrary, the court shall adjudge that the estate of the deceased in the Philippines, after the payment of just debts and charges, shall escheat, and shall, pursuant to law, assign the personal estate to the municipality or city where he last resided in the Philippines, and the real estate to the municipalities or cities, respectively, in which the same is situated. If the deceased never resided in the Philippines, the whole estate may be assigned to the respective municipalities or cities where the same is located. Estate shall be for the benefit of public schools, and public charitable institutions and centers in said municipalities or cities. The court, at the instance of an interested party, or on its own motion, may order the establishment of a permanent trust, so that the only income from the property shall be used. Section 4. When and by whom claim to estate filed. If a devisee, legatee, heir, widow, widower, or other person entitled to such estate appears and files a claim thereto with the court within 5 years from the date of such judgment, such person shall have possession of and title to the same, or if sold, the municipality or city shall be accountable to him for the proceeds after deducting reasonable charges for the care of the estate, but a claim not made within the said time shall be forever barred. Section 5. Other actions for escheat. Until otherwise provided by law, actions reversion, or escheat of properties alienated in violation of the Constitution or of any statute shall be governed by this rule, except that the action shall be instituted in the province where the land lies in whole or in part. General Guardians and Guardianship. Rule 92. Venue. Section 1. Where to institute proceedings. Guardianship of a person or estate of a minor or incompetent may be instituted in the Court of First Instance of the province, or in the Justice of the Peace Court of the municipality, or in the municipal court chartered city where the minor or incompetent persons resides, and if he resides in a foreign country, in the Court of First Instance of the province wherein his property or the party thereof is situated, provided, however, that where the value of the property of such minor or incompetent exceeds that jurisdiction of the Justice of the Peace or municipal court, the proceedings shall be instituted in the Court of First Instance. In the city of Manila the proceedings shall be instituted in the Juvenile and Domestic Relations Court. Section 2. Meaning of word incompetent. Under this rule, the word incompetent includes persons suffering the penalty of civil interdiction or who are hospitalized lepers, prodigals, deaf and dumb who are unable to read and write, those who are of unsound mind, even though they have lucid intervals, and persons not being of unsound mind, but by reason of age, disease, weak mind, and other similar causes, cannot, without outside aid, take care of themselves and manage their property, becoming thereby an easy prey for deceit and exploitation. Section 3. Transfer of venue. The court taking cognizance of a guardianship proceeding, may transfer the same to the court of another province or municipality wherein the ward has acquired real property, if he has transferred thereto his bona fide residence, and the latter court shall have full jurisdiction to continue the proceedings, without requiring payment of additional court fees. Rule 93. Appointment of guardians. Section 1. Who may petition for appointment of guardian for resident? Any relative, friend, or other person on behalf of a resident minor or incompetent who has no parent or lawful guardian, or the minor himself if 14 years of age or over, may petition the court having jurisdiction for the appointment of a general guardian for the person or estate, or both, of such minor or incompetent. An officer of the Federal Administration of the United States in the Philippines may also file a petition in favor of award thereof, and the Director of Health, in favor of an insane person who should be hospitalized, or in favor of an isolated leper. Section 2. Contents of petition. A petition for the appointment of a general guardian must show, so far as known to the petitioner, a. the jurisdiction facts, b. the minority or incompetency rendering the appointment necessary or convenient, c. the names, ages, and residence of the relatives of the minor or incompetent, and of the person having him in their care, d. the probable value and character of his estate, e. the name of the person for whom letters of guardianship. The petition shall be verified, but no defect in the petition or verification shall render void the issuance of letters of guardianship. Section 3. Court to set time for hearing. Notice thereof. When a petition for the appointment of a general guardian is filed, the court shall fix a time and place for hearing the same, and shall cause reasonable notice thereof to be given to the persons mentioned in the petition residing in the province, including the minor if above 14 years of age or the incompetent himself, and may direct other general or special notice thereof to be given. Section 4. Opposition to petition. Any interested person may, by filing a written opposition, contest the petition on the ground of majority of the alleged minor, competency of the alleged incompetent, or the unsuitability of the person for whom letters are prayed, and may pray that the petition be dismissed, or that letters of guardianship issue to himself, or to any suitable person named in the opposition. Section 5. Hearing and order for letters to issue. At the hearing of the petition the alleged incompetent must be present if able to attend, and it must be shown that the required notice has been given. Thereupon the courts shall hear the evidence of the parties in support of their respective allegations, and, if the person in question is a minor, or incompetent, it shall be appoint a suitable guardian of his person or estate, or both, with the powers and duties hereinafter specified. Section 6. When and how guardian for non-resident appointed. Notice. When a person liable to be put under guardianship resides without the Philippines but the estate therein, any relative or friend of such person, or anyone interested in his estate, in expectancy, or otherwise, may petition a court having jurisdiction for the appointment of a guardian for the estate, and if, after notice given to such person and in such manner as the court deems proper, by publication or otherwise, and hearing, the court is satisfied that such non-resident is a minor or incompetent rendering a guardian necessary or convenient, it may appoint a guardian for such estate. Section 7. Parents as guardians. When the property of the child under parental authority is worth 2,000 pesos or less, the father of the mother, without the necessity of court appointment, shall be his legal guardian. When the property of the child is worth more than 2,000 pesos, the father or the mother shall be considered guardian of the child's property, with the duties and obligations of guardians under this rules, and shall file the petition required by Section 2 hereof. For good reasons the court may, however, appoint another suitable person. Section 8. Service of judgment. Final orders or judgments under this rule shall be served upon the civil registrar of the municipality or city where the minor or incompetent person resides or where his property or part thereof is situated. Rule 94. Bonds of guardians. Section 1. Bond to be given before issuance of letters. Amount. Condition. Before a guardian appointed enters upon the execution of his trust, or letters of guardianship issue, he shall give a bond, in such sum as the court directs, conditioned as follows. A. To make and return to the court, within 3 months, a true and complete inventory of all the estate, real and personal, of his ward which shall come to his possession or knowledge of any other person for him. B. To faithfully execute the duties of his trust, to manage and dispose of the estate according to these rules for the best interests of the ward, and to provide for the proper care, custody, and education of the ward. C. To render a true and just account of all the estate of the ward in his hands, and of all proceeds or interest derived therefrom, and of the management and disposition of the same, at the time designated by these rules and such other times as the courts directs, and at the expiration of his trust to settle his accounts with the court and deliver and pay over all the estate, effects, and monies remaining in his hands, or due from him on such settlement, to the person lawfully entitled thereto. D. To perform all orders of the court by him to be performed. Section 2. When new bond may be required and old sureties discharged. Whenever it is deemed necessary, the court may require a new bond to be given by the guardian, and may discharge the sureties on the old bond from further liability, after due notice to interested persons, when no injury can result therefrom to those interested in the estate. Section 3. Bonds to be filed. Actions thereon. Every bond given by a guardian shall be filed in the office of the clerk of the court, and, in case of the breach of a condition thereof, may be prosecuted in the same proceeding or in a separate action for the use and benefit of the ward or of any other person legally interested in the estate. Rule 95. Selling and encumbering property of ward. Section 1. Petition of guardian for leave to sell or encumber estate. When the income of the estate under guardianship is insufficient to maintain the ward and his family, or to maintain and educate the ward when a minor, or when it appears that it is for the benefit of the ward that his real estate or some part thereof be sold, or mortgaged, or otherwise encumbered, and the proceeds thereof put out at interest, or invested in some productive security, or in the improvement or security or other real estate of the ward, the guardian may present a verified petition to the court by which he was appointed setting forth such facts, and praying that an order issue authorizing the sale or encumbrance. Section 2. Order to show cause thereupon. If it seems probable that such sale or encumbrance is necessary, or would be beneficial to the ward, the court shall make an order directing the next of kin of the ward, and all persons interested in the estate, to appear at a reasonable time and place therein specified to show cause why the prayer of the petition should not be granted. Section 3. Hearing on return of order. Costs. At the time and place designated in the order to show cause, the court shall hear the proofs and allegations of the petitioner and next of kin, and other persons interested, together with their witnesses, and grant and refuse the prayer of the petition as the best interest of the ward require. The court shall make such order as to cost of the hearing as may be just. Section 4. Contents of order for sale or encumbrance, and how long effective. Bond. If, after full examination, it appears that it is necessary, or would be beneficial to the ward, to sell or encumber the estate, or some portion of it, the court shall order such sale or encumbrance and that the proceeds thereof be expended for the maintenance of the ward and his family, or the education of the ward, if a minor, or for the putting of the same interest, or the investment of the same as the circumstances may require. The order shall specify the causes why the sale or encumbrance is necessary or beneficial, and may direct that estate ordered sold be disposed of at either public or private sale, subject to such conditions as to the time and manner of payment, and security where a part of the payment is deferred as in the discretion of the court are deemed most beneficial to the ward. The original bond of the guardian shall stand as security for the proper appropriation of the proceeds of the sale, but the judge may, if deemed expedient, require an additional bond as a condition for the granting of the order of sale. No order of sale granted in pursuance of this section shall continue in force more than 1 year after granting the same, without a sale being had. Section 5. Court may order investment of proceeds and direct management of estate. The court may authorize and require the guardian to invest the proceeds of sales or encumbrances, and any other of his ward's money in his hands, in real estate or otherwise, as shall be for the best interest of all concerned, and may make such other orders for the management, investment, and disposition of the estate and effects, as circumstances may require. Rule 96. General powers and duties of guardians. Section 1. To what guardianship shall extend. A guardian appointed shall have the care and custody of the person of his ward, and the management of his estate, or the management of the estate only, as the case may be. The guardian of the estate of a non-resident shall have the management of all the estate of the ward within the Philippines, and no court other than that in which such guardian was appointed shall have jurisdiction over the guardianship. Section 2. Guardian to pay debts of ward. Every guardian must pay the ward's just debts out of his personal estate and the income of his real estate, if sufficient; if not, then out of his real estate upon obtaining an order for the sale or encumbrance thereof. Section 3. Guardian to settle accounts, collect debts, and appear in actions for ward. A guardian must settle all accounts of his ward, and demand, sue for, and receive all debts due him, or may, with the approval of the court, compound for the same and give discharges to the debtor, on receiving a fair and just dividend of the estate and effects, and he shall appear for and represent his ward in all actions and special proceedings, unless another person be appointed for that purpose. Section 4. Estate to be managed frugally, and proceeds applied to maintenance of ward. A guardian must manage the estate of his ward frugally and without the waste, and apply the income and profits thereof, so far as may be necessary, to the comfortable and suitable maintenance of the ward and his family, if there be any, and if such income and profits be insufficient for that purpose, the guardian may sell or encumber the real estate, upon being authorized by order so to do, and apply to such of the proceeds as may be necessary to such maintenance. Section 5. Guardian may be authorized to join in partition proceedings after hearing. The court may authorize the guardian to join in an assent to a partition of real or personal estate held by the ward jointly or in common with others, but such authority shall only be granted after hearing, upon such notice to relatives of the ward as the court may direct, and a careful investigation as to the necessity and propriety of the proposed action. Section 6. Proceedings when the person suspected of embezzling or concealing property of ward. Upon complaint of the guardian or ward, or of any person having actual or prospective interest in the estate of the ward as creditor, heir, or otherwise, that anyone is suspected of having embezzled, concealed, or conveyed away any money, goods, or interest, or a written instrument, belonging to the ward or his estate, the court may cite the suspected person to appear for examination touching such money, goods, interest, or instrument, and make such orders as will secure the estate against such embezzlement, concealment, or conveyance. Section 7. Inventories and accounts of guardians, and appraisement of estates. A guardian must render to the court an inventory of the estate of his ward within 3 months after his appointment, and annually after such appointment an inventory and account, the rendition of any of which may be compelled upon the application of an interested person. Such inventories and accounts shall be sworn to by the guardian. All the estate of the ward described in the first inventory shall be appraised. In the appraisement the court may request the assistance of one or more of the inheritance tax appraisers. And whenever any property of the ward not included in an inventory already rendered is discovered, or seized to, or acquired by the ward, like proceedings shall be had for securing an inventory and appraisement thereof within 3 months after such discovery, succession, or acquisition. Section 8. When guardian's accounts presented for settlement. Expenses and compensation allowed. Upon the expiration of a year from the time of his appointment, and as often thereafter as may be required, a guardian must present his account to the court for settlement and allowance. In the settlement of the account, the guardian, other than a parent, shall be allowed the amount of his reasonable expenses incurred in the execution of his trust and also such compensation for his services as the court deems just, not exceeding 15% of the net income of the ward. Rule 97. Termination of guardianship. Section 1. Petition that competency of ward be adjudged, and proceedings thereupon. A person who has been declared incompetent for any reason, or his guardian, relative, or friend, may petition the court to have his present competency judicially determined. The petition shall be verified by oath, and shall state that such person is then competent. Upon receiving the petition, the court shall fix a time for hearing the questions raised thereby, and cause reasonable notice thereof to be given to the guardian of the person so declared incompetent, and to the ward. On the trial, the guardian, or relatives of the ward, and, in the discretion of the court, any other person, may contest the right to the relief demanded, and witnesses may be called and examined by the parties or by the court on its own motion. If it be found that the person is no longer incompetent, his competency shall be adjudged and the guardianship shall cease. Section 2. When the guardian removed or allowed to resign. New appointment. When a guardian becomes insane or otherwise incapable of discharging his trust or unsuitable therefore, or has wasted or mismanaged the estate, or failed for 30 days after it is due to render an account or make a return, the court may, upon reasonable notice to the guardian, remove him, and compel him to surrender the estate of the ward to the person found to be lawfully entitled thereto. A guardian may resign when it appears proper to allow the same, and upon his resignation or removal the court may appoint another in his place. Section 3. Other termination of guardianship. The marriage or voluntary emancipation of a minor ward terminates the guardianship of the pason of the ward, and shall enable the minor to administer his property as though he were of age, but he cannot borrow the money or alienate or encumber real property without the consent of his father or mother, or guardian. He can sue and be sued in court only with the assistance of his father, mother, or guardian. The guardian of any person may be discharged by the court when it appears, upon the application of the ward or otherwise, that the guardianship is no longer necessary. Section 4. Record to be kept by the justice of the peace or municipal judge. When a justice of the peace or municipal court takes cognizance of the proceedings in pursuance of the provisions of these rules, the record of the proceedings shall be kept as in the court of first instance. Section 5. Service of judgment. Final orders of judgments under this rule shall be served upon the civil registrar of the municipality or city where the minor or incompetent person resides or where his property or part thereof is situated. Rule 98. Trustees. Section 1. Where trustee appointed. A trustee necessary to carry into effect the provisions of a will on written instrument shall be appointed by the court of first instance in which the will was allowed, if it be a will allowed in the Philippines, otherwise by the court of first instance of the province in which the property, or some portion thereof, affected by the trust is situated. Section 2. Appointment and powers of trustees under will. Executor of former trustee need not administer trust. If a testator has omitted in his will to appoint a trustee in the Philippines, and if such appointment is necessary to carry into effect the provisions of the will, the proper court of first instance may, after notice to all persons interested, appoint a trustee who shall have the same rights, powers, and duties, and in whom the estate shall vest, as if he had been appointed by the testator. No person succeeding to a trust as executor or administrator of a former trustee shall be required to accept such trust. Section 3. Appointment and powers of new trustee under written instrument. When a trustee under a written instrument declines, resigns, dies, or removed before the objects of the trust are accomplished, and no adequate provision is made in such instrument for supplying the vacancy, the proper court of first instance may, after due notice to all persons interested, appoint a new trustee to act alone or jointly with the others, as the case may be. Such new trustee shall have and exercise the same powers, right, and duties as if he had been originally appointed, and the trust estate shall vest in him in like manner as it had vested or would have vested, in the trustee in whose place he is substituted, and the court may order such conveyance to be made by the former trustee or his representatives, or by the other remaining trustees, as may be necessary or proper to vest the trust estate in the new trustee, either or jointly with the others. Section 4. Proceedings where trustee appointed abroad. When land in the Philippines is held in trust for persons resident here by a trustee who derives his authority from without the Philippines, such trustee shall, on petition filed in the court of first instance of the province where the land is situated, and after due notice to all persons interested, be ordered to apply to the court for appointment as trustee, and upon his neglect or refusal to comply with such order, the court shall declare such trust vacant, and shall appoint a new trustee, in whom the trust estate shall vest in like manner as if he had been originally appointed by such court. Section 5. Trustee must file bond. Before entering on the duties of his trust, a trustee shall file with the clerk of the court having jurisdiction of the trust a bond in the amount fixed by the judge of said court, payable to the government of the Philippines and sufficient and available for the protection of any party in interest, and a trustee who neglects to file such bond shall be considered to have declined or resigned the trust, but the court may until further order exempt a trustee under a will from giving a bond when the testator has directed or requested such exemption, and may so exempt any trustee when all persons beneficially interested in the trust, being of full age, request the exemption. Such exemption may be cancelled by the court at any time, and the trustee required to forthwith file a bond. Section 6. Conditions included in bond. The following conditions shall be deemed to be part of the bond whether written therein or not. A. That the trustee will make and return to the court, at such time as it may order, a true inventory of all the real and personal estate belonging to him as trustee, which at the time of the making of such inventory shall have come to his possession or knowledge. B. That he will manage and dispose of all such estate, and faithfully discharge his trust in relation thereto, according to law and the will of the testator or the provisions of the instrument or order under which he is appointed. C. That he will render upon oath at least once a year until his trust is fulfilled, unless he is excused therefrom in any year by the court, a true account of the property in his hands and the management and disposition thereof, and will render such other accounts as the court may order. D. That at the expiration of his trust he will settle his account in court and pay over and deliver all the estate remaining in his hands, or due from him on such settlement, to the person or persons entitled to thereto. But when the trustee is appointed as a successor to a prior trustee, the court may dispense with the making and return of an inventory, if one has already been filed, and in such case the condition of the bond shall be deemed to be altered accordingly. Section 7. Appraisal. Compensation of trustee. When an inventory is required to be returned by a trustee, the estate and effects belonging to the trust shall be appraised, and the court may order one or more inheritance tax appraisers to assist in the appraisement. The compensation of the trustee shall be fixed by the court, if it be not determined in the instrument creating the trust. Section 8. Removal or resignation of trustee. The proper court of first instance may, upon petition of the parties beneficially interested and after due notice to the trustee and hearing, remove a trustee if such removal appears essential in the interest of the petitioner. The court may also, after due notice to all persons interested, remove a trustee who is insane or otherwise incapable of discharging his trust or evidently unsuitable therefor. A trustee, whether appointed by the court or under a written instrument, may resign his trust if it appears to the court proper to allow such resignation. Section 9. Proceedings for sale or encumbrance of trust estate. When the sale or encumbrance of any real or personal estate held in trust is necessary or expedient, the court having jurisdiction of the trust may, on petition and after due notice and hearing, order such sale or encumbrance to be made, and the reinvestment and application of the proceeds thereof in such manner as will best affect the objects of the trust. The petition, notice, hearing, order of sale or encumbrance, and record of proceedings, shall conform as nearly as may be to the provisions concerning the sale or encumbrance by guardians of the property of minors or other wards. Rule 99. Adoption and custody of minors. New rule on adoption, effective August 22, 2002. Section 1. Venue. A person desiring to adopt another or have the custody of a minor shall present his petition to the court of first instance of the province, or the municipal or justice of the peace court of the city or municipality in which he resides. In the city of Manila, the proceedings shall be instituted in the Juvenile and Domestic Relations Court. Section 2. Contents of petition. The petition for adoption shall contain the same allegations required in a petition for guardianship, to wit: a. The jurisdictional facts. b. The qualification of the adopter. c. That the adopter is not disqualified by law. d. The name, age, and residence of the person to be adopted and of his relatives of the persons who have him under their care. e. The probable value and character of the estate of the person to be adopted. Section 3. Consent of adoption. There shall be filed with the petition a written consent to the adoption signed by the child, if 14 years of age or over and not incompetent, and by the child's spouse, if any, and by each of its known living parents who is not insane or hopelessly intemperate or has not abandoned such child, or if there is no such parents by the general guardian or guardian ad litem of the child, or if the child is in the custody of an orphan asylum, children's home, or benevolent society or person, by the proper officer of such asylum, home, or society, or by such person, but if the child is illegitimate and has not been recognized, the consent of its father to the adoption shall not be required. If the person to be adopted is of age, only his or her consent and that of the spouse, if any, shall be required. Section 4. Order for hearing. If the petition and consent filed are sufficient in form and substance, the court, by an order reciting the purpose of the petition, shall fix a date and place for the hearing thereof, which shall not be more than 6 months after the entry of the order, and shall direct that a copy of the order be published before the hearing at least once a week for 3 successive weeks in some newspaper of general circulation published in the province, as the court shall deem best. Section 5. Hearing and judgment. Upon satisfactory proof in open court on the date fixed in the order that such order has been published as directed, that the allegations of petition are true, and that it is a proper case for adoption and the petitioner or petitioners are able to bring up and educate the child properly, the court shall adjudge that thenceforth the child is free from all legal obligations of obedience and maintenance with respect to its natural parents, except the mother when the child is adopted by her husband, and is, to all legal intents and purposes, the child of the petitioner or petitioners, and that its surname is changed to that the petitioner or petitioners. The adopted person or child shall thereupon become the legal heir of his parents by adoption and shall also remain the legal heir of his natural parents. In case of the death of the adopted person or child, his parents and relatives by nature, and not by adoption, shall be his legal heirs. Section 6. Proceedings as to the child whose parents are separated. Appeal. When husband and wife are divorced or living separately and apart from each other, and the question as to the care, custody, and control of a child or children of their marriage is brought before a court of first instance by petition or as an incident to any other proceeding, the court, upon hearing the testimony as may be pertinent, shall award the care, custody, and control of each such child as will be for its best interest, permitting the child to choose which parent it prefers to live with if it be over 10 years of age, unless the parent so chosen be unfit to take charge of the child by the reason of moral depravity, habitual drunkenness, incapacity, or poverty. If, upon such hearing, it appears that both parents are improper persons to have the care, custody, and control of the child, the court may either designate the paternal or maternal grandparent of the child, or his oldest brother or sister, or some reputable and discreet person to take charge of such child, or commit it to any suitable asylum, children's home, or benevolent society. The court may, in conformity with the provisions of the Civil Code, order either or both parents to support or help support said child, irrespective of who may be its custodian, and may make any order that is just and reasonable permitting the parent who is deprived of its care and custody to visit the child or have temporary custody thereof. Either parent may appeal from an order made in accordance with the provisions of this section. No child under 7 years of age shall be separated from its mother, unless the court finds there are compelling reasons thereof. Section 7. Proceedings as to vagrant or abused child. When the parents of any minor child are dead, or by reason of long absence or legal or physical disability have abandoned it, or cannot support it through vagrancy, negligence, or misconduct, or neglect or refuse to support it, or treat it with excessive harshness or give it corrupting orders, counsels, or examples, or cause or allow it to engage in begging, or to commit offenses against the law, the proper court of first instance, upon petition filed by some reputable resident of the province setting forth the facts, may issue an order requiring such parents to show cause, or, if the parents are dead or cannot be found, requiring the fiscal of the province to show cause, at a time and place fixed in the order, why the child should not be taken from its parents, if living, and if upon the hearing it appears that the allegations of the petition are true, and that it is ordered taking it from its parents, if living, and committing it to any suitable orphan asylum, children's home, or benevolent society or person to be ultimately placed, by adoption or otherwise, in a home found for it by such asylum, children's home, society, or person. Section 8. Service of judgment. Final orders or judgments under this rule shall be served by the clerk upon the civil registrar of the city or municipality wherein the court issuing the same is situated. Rule 100. Rescission and revocation of adoption. Section 1. Who may file petition, grounds. A minor or other incapacitated person may, through a guardian or guardian ad litem, petition for the rescission or revocation of his or her adoption for the same causes that authorize the deprivation of parental authority. The adopter may, likewise, petition the court for the rescission or revocation of the adoption in any of these cases. A. If the adopted person has attempted against the file of the adopter. B. When the adopted minor has abandoned the home of the adopter for more than 3 years. C. When by other acts the adopted person has repudiated the adoption. Section 2. Order to answer. The court in which the petition is filed shall issue an order requiring the adverse party to answer the petition within 15 days from receipt of a copy thereof. The order and a copy of the petition shall be served on the adverse party in such manner as the court may direct. Section 3. Judgment. If upon trial, on the day set therefor, the court finds that the allegations of the petition are true, it shall render judgment ordering the rescission or revocation of the adoption, with or without costs, as justice requires. Section 4. Service of judgment. A certified copy of the judgment rendered in accordance with the next preceding section shall be served upon the civil registrar concerned, within 30 days from rendition thereof, who shall forthwith enter the action taken by the court in the register. Section 5. Time within which to file petition. A minor or other incapacitated person must file the petition for rescission or revocation of adoption within the 5 years following his majority, or if he was incompetent at the time of the adoption, within the 5 years following the recovery from such incompetency. The adopter must also file the petition to set aside the adoption within 5 years from the time the cause or causes giving rise to the rescission or revocation of the same took place.